So I don't think that the motion for relief from judgment that was filed by Brenay's lawyer the other day is going to get very far. It's sort of weak argument. In theory, she was prejudiced by her lawyer withdrawing right at the end. The lack of discovery is potentially a problem, but again, she could have gotten a lawyer. A lawyer could have argued that the trial wasn't ripe to pursue, and they needed more discovery, although a lot of evidence was submitted. I think that argument's a little weak. I don't think it'll work in a Rule 59 motion, even though it's been argued in the motion. I think that the notion that the elements of alienation of affection weren't proven is an interesting argument. Basically they didn't have a loving marriage, and if you didn't have a loving marriage, you can't have an alienation of affection because it was alienated before all of this happened, because there was an affair that occurred before, and so therefore there wasn't a loving and happy and stable marriage. That argument actually isn't that bad, and it may help to knock out one of the elements, which if one of the elements isn't present, then potentially you could throw the whole verdict out. I don't see the judge doing this, but there's the possibility that may work on appeal. Now, whether or not Brenay's going to have this lawyer on appeal, I don't know. The brief wasn't bad. It wasn't, stellar. I would have argued more things, but she may be holding some stuff back for the appeal. Rule 59 motions rarely work unless something's just way out of whack. And I don't think it was. Again, I have to read the transcript. So I think Rule 59 motion looks a little weak. The appeals would be hard to even, get the court to entertain an oral argument. Probably not likely. It's likely to be just on the briefs. But if you lose at the Court of Appeals, you can appeal to the North Carolina Supreme Court. And most of the time, they're not going to be willing to hear it either. They'll just issue a decision based on the briefs. But that's going to delay everything quite a bit and make it hard to get paid. And maybe pause everything altogether. It's just hard to say, but generally when you appeal, it's not you appeal it. It's sort of like there's a stay that's in place, and you can't really can't do anything on it because it's being questioned. So it's going to slow things down dramatically. But I think the Rule 59 motion's weak, just because there aren't many grounds, and then I think an appeal would be difficult to win. But you never know. Court of Appeals make some crazy decisions sometimes, so who knows?